and I'm going to turn it over to Victoria Collier. Go ahead, Victoria.
Great. Thank you, Maggie. I appreciate that. And yes, we've known each other, I think, close to 15 years because I founded my practice, the Estate and Asset Protection Law Firm, which 16 years ago was called the Elder and Disability Law Firm at Victoria Collier. And so we met within my first year or two of practice. And it's been a wonderful relationship because, as Maggie said, we have worked on some cases together, some of them complex. And as I share with as many people as I can in the community, legal planning, estate planning is good and it's necessary. Financial planning and wealth protection is good and it's necessary. But done independent of the other, they can actually harm each other. And so working as a team with advisors from their different angles is how we get the best protection. Okay. Now today, we're going to focus our conversation on the tax advantage trust planning and protecting assets leveraged by your wealth advisor. And the reason for that is that what we find is that wealth advisors work really hard at preserving and growing your assets, but yet the clients don't do what's necessary to then protect losing 35% of it at death. And so we want to look at some wonderful ways that we use different types of trusts to protect losing the money that your advisors have worked so hard to maintain and grow for you. So I appreciate Maggie and Chicory Wealth having me today to be able to present this to your clients, your colleagues, and as well as our community. And I am Victoria Collier. I'm a lawyer. I'm a certified elder law attorney, and I founded the Estate and Asset Protection Law Firm. And because I'm a lawyer, I have to give out these disclosures that says that this, in fact, is an educational presentation and is not legal advice. What we talk about today are going to be concepts that may or may not be suitable for individuals. And so each one may be different depending on personal situations. And so this is education only, it's not legal advice. And so for those of you who don't know me that's on the call, that's a little picture of me. And in addition to being a lawyer, I'm a licensed insurance agent. That's not the same thing as a wealth advisor, but I do have a lot more education in the financial world because of my license in insurance, and that helps the relationship between the advisor and the lawyer's office to be able to talk the same language so that we can best help our client. Whereas lawyers don't always talk the same language as wealth advisors and vice versa. And so this gives a bit of a bridge into that relationship. Our national organization for elder law attorneys is called the National Elder Law Foundation. And I am the only practicing lawyer in Georgia who has the designation of fellow, which is the highest level of award that this organization provides to their members. I am also a wartime veteran, which is helpful for clients who are planning for long-term care, because for certain types of veterans, wartime veterans who meet certain criteria, that can be an added way to protect your resources, because we can get sometimes additional income from the VA to pay for care. We won't be talking about that today, but that's why it's relevant in my background here. I've written several books and on the subject matters that we're talking about and others. And I go across the nation and I teach other lawyers about the specialty that we do here in Georgia. What I don't have on here, but I talk about at the very end, is that I'm only licensed in Georgia, and I know that Maggie, you service clients across the United States. I also do have a lawyer in Michigan that is actually in my office here, but he's licensed in Michigan. So we can actually, on the legal side, help people in both Georgia and Michigan. And this is my team. I'm, share this information as far as my team because, like Maggie's office, we are a team of professionals to help our clients. And it's a business that we run. It's not a practice that we run. And so I have a COO, Shannon Pauley, who is a lawyer. She has her master's in tax, and she runs the business side of our office to make sure that our case flow goes through where it's supposed to go through, and that our clients are serviced the way that we promised that they should be. Charles is the lawyer who is here, but licensed in Michigan and pending his license in Georgia. I have a law clerk who is just phenomenal that will be graduating in May and will be joining us as a lawyer in November. And yes, it takes that long to study for the bar and get your results. And then we've got specialized paralegals and other legal assistants in the team. So, when someone utilizes our office, we as a team service that client. It's not dependent on Victoria being here or Charles being here because the whole entire team is working together. So before I begin everything else, I think it's important for you to at least know what my mission is, because I do everything through the eyes of my mission. And that's to include putting educational information out for others. And my mission is to ensure that people live and die with the highest quality of life possible. And the reason why I say and die is because, to me, in the plans we help people put together, dying is a part of life. And we have to plan for it as much as we plan for the living. I'm hearing some interference, just so you know. So how do we go about carrying out our personal mission to ensure that people live and die with the highest quality of life? Well, number one, we have to listen to what's important to people. Instead of imposing our views or our judgment on what someone should or shouldn't do, we listen to what's most important to them. We listen to their fears. We listen to their joys and goals. And we also educate. This is one example of the education. And then through all of that, we help prepare solid estate plans designed around their self-directed choices to preserve their independence while they're alive, and then their assets both while they're alive and when they transition through death and prior to death through disability. So what I find that people are most afraid of that lead to planning is they're afraid of losing all their assets to the government, either through income taxes or estate taxes. They're afraid of losing all their assets due to an illness, whether that be a short-term illness or a long-term illness. Losing their house to foreclosure or bankruptcy. The number one reason for bankruptcy in the United States is due to illness for people who are under the age of 65. So this is not a senior citizen issue. This is not an old person issue. This is planning that should be done for anybody who has accumulated anything of value that they want to protect. People are afraid of having someone else, whether that's a friend, family member, stranger, or professionals, take advantage of them. I know of a very well-to-do individual in Atlanta that had a very large law firm take care of their estate for decades upon decades. And I'm talking hundreds of millions of dollars. And when the spouse, the first spouse died, the lawyer of the large law firm retired and passed the estate over for management to another lawyer. And that lawyer, over approximately 15 years, proceeded to use a shell game and transfer everything to himself, all with the presumed agreement from the surviving spouse, which wasn't agreement. Let me just tell you, it was lack of knowledge and too much trust in the professionals. And so, you know, that's the big fear of people, not always from professionals, but just from others. People are afraid of losing all their independence. I hear that more than anything. Don't take my car keys away. I don't want to leave my house that I've lived in for 30 years. You know, however they define independence to themselves, they're afraid of losing that. And then ultimately, nobody wants to move to a nursing home. So how can we avoid that? And even though people are afraid of these things still happen. And the question is, why do these things still happen? Well, number one is people don't know their options. And that's because sometimes they don't want to know their options. So they bury their head in the sand. But other times they try to do their own research on the internet, and there's just so much information that it's overwhelming and you don't know what to believe. So you just stop looking. The other is, even after getting good education, after getting good counsel, they just don't take action. And at that point, all that education, all that good counsel is really just entertainment. Because if you don't do anything with it, then you might as well have just gone to the movie with that time. So a certain percentage of people will certainly hear this webinar today, and they still won't take action. And sometimes it's because the last point, people just don't believe that it's going to happen to them. It happens to everyone around them. Everybody can raise their hand and say, yes, I know somebody that needed long-term care. Yes, I know somebody that went in a nursing home. Yes, I know somebody that died without a will. But it's not going to happen to me. And so we just don't do any planning. So let me give you a couple examples of where it did happen, of people that you may know, or at least know of. Joe Robbie. Joe Robbie was an attorney, but that's not what he's most known for. He was a politician, but that's not what he's most known for. What he is known for is he was the founder and owner of the Miami Dolphins, to include building the entire Miami Dolphins stadium. And so he had a substantial amount of net worth when he died. The thing is, Joe Robbie did planning. I don't know if he did his own planning as a lawyer, which you are a fool if you're a lawyer and you represent yourself, or if he used someone else to do his planning. But his planning consisted of what's called a revocable living trust. And many people will put their assets into a revocable living trust for the purpose of avoiding probate. And from what I understand, probate in Florida may be a difficult, expensive process. And certainly, I assume Joe Robbie lived in Florida, given that he was the founder of the Miami Dolphins. So maybe he wanted to avoid probate, and that's fine. But what he didn't do was anything to protect his family from the taxes that his estate would have to pay when he died based on his net worth, which was hundreds of millions of dollars. And so what happened was that his family literally had to sell the Miami Dolphins as well as the stadium just to pay off the taxes. So they didn't get anything, and they didn't even get the benefit of his legacy of founding the Miami Dolphins. That likely was not his intent, but his intent was to go on the cheap or just not get the information he needed to protect his personal situation versus the masses following what the masses do, which is, if you want to avoid probate, get a revocable trust. The next scenario is Prince. Prince, the formerly known artist as the Prince, came back as Prince. He was an entertainer. He died with no will. Now, he also had millions of dollars, but I don't want to highlight that. What I want to highlight is the fact that he died without a will. You know, these people have advisors all around them. but they're not getting the right advice, or they're not taking the action that they are getting. And we don't know because they're dead, so we can't ask them at this point. But I will tell you this: when you die without a will, the state that you are a resident of when you die decides who gets your stuff. And then they also, in his case, he had to pay estate taxes too. But in this case, the people who came out of what they say the woodwork, saying that they were his relatives to get part of his estate, was interesting. But what's more interesting is how the court ruled on that. So, for example, the way I understand it, Prince had a father, and his father took in another boy and treated him like his own son, even though he wasn't his own son. And then that boy turned into a man, and then that man had two children, a son and a daughter. And so they were kind of like Prince's niece and nephew. And Prince and this other guy treated each other like brothers. And so when Prince died, his father was already dead. And when Prince died, this kind of like a brother was already dead. And so his kind of like niece and nephews said, hey, we are actual niece and nephews, because they always treated us like that. And we have an expectation to inherit from Prince because Prince doesn't have a spouse, Prince doesn't have any children, and therefore it extends out to his siblings. And this guy was a sibling just as much as any other sibling. And the amazing thing is there's a judge that agrees with them. And so things like this and so many other stories I could share with you happen every day, and not just to celebrities, but they happen to regular people like us. So today I'd like to ask you, how open-minded will you be about seeing new options to protect your family and your life savings that maybe you haven't heard from other advisors because other advisors are following the herd, okay? And so you don't have to be part of the herd. You're an individual. Let's see what could apply to you. And so today's agenda, what we're going to talk about is the estate tax is dead. Now, it's not necessarily dead, but it might be in hibernation, and we'll talk about that a little bit. We're going to talk about the basics on trust, because today's agenda is all about trust. So I want to make sure that you understand the basics before we then get into the income tax planning through the use of 3 different types of very specific trusts. So estate tax is dead or hibernating. So what do I mean by that? So when I see clients, I typically ask them 14 questions that I have on what we call our estate planning audit. And one of those questions is, I want you to rank from 1 to 10 how important it is to you, with 0 being it's not important to me, Victoria, stop talking about it, and 10 is, oh my gosh, I lose sleep over this. How important is it to you to avoid estate taxes? And 8 out of 10 people will say, oh my gosh, that's a 10. And I'll tell you, in my practice, I'm not sure about you, Maggie, but in my practice, I don't have people who are in the situation where they have to worry about estate taxes. And why is that? That's because your state, from a federal standpoint, from a federal estate tax standpoint, you have to have, as a single individual, over $11,400,000 before the federal government is going to tax your estate. And if you're married, that's twice that. So that's $22,800,000. And I just don't have clients like that yet. Someday I might. And you'll see that that graduates even higher and higher and higher until 2025. Now, certainly, the reason I say it might just be hibernating is that can change at any time with a change of political party, with any kind of, wave in politics. But that's what it is for right now. And then it's expected to come back down in 2026, down to about the 6 million limit for a single, and then it would be double for that for married. Now that might actually reach more people where it's concerning, which means that we might still today, if we have a life expectancy beyond 10 years from now, might still want to plan for that contingency of when it comes back down. Now in Georgia, for example, the state of Georgia follows the estate tax regime of the federal government. Not all states do. So in some states, you might have a state estate tax issue, but not a federal one unless your value is over $11 million, okay? So for most of us, this is not an issue. But what is a real issue that the other advisors are not talking about are the capital gains taxes that people can minimize or outright avoid altogether, at least for a certain period of time. And that's what we want to focus on today. So let's talk about the basics of trusts. What is a trust? This is Trust 101, because some people on this call will probably have trust already, but some of you may not, and this is what's of interest to you, is finding out, should you even have one at all? Not just what type, but should you have one? So a trust itself is just a stack of pieces of paper with lots of legal words in them that form a contract. And so whenever we have a contract, we have a relationship between parties. And with a trust, it's a fiduciary relationship. Just like Maggie and her advisors have to have a fiduciary relationship with you, which means that she has to only recommend things that are in your best interest. Just like lawyers have a fiduciary duty to their client, which means I can only recommend what I feel is in their best interest. A trust, all the parties within that have a fiduciary relationship as well. So the first party is what's called the trust maker. That's the person who wants to create the trust to begin with and put their own money into it, okay? Then the second party is the trustee. That's the person who manages the money. And I don't mean like Maggie who manages. I mean the person on the day-to-day basis who has legal authority over the money, who hires money managers to actually do the investments. But the trustee is the one with the legal authority to touch the money, invest the money, transfer the money, all that kind of stuff. And then the third interesting individual is called the beneficiary. There's beneficiaries during our lifetime. So the people who can benefit from the money in the trust while we're alive. And then there's what's called death beneficiaries, people who receive, or organizations who receive, the assets when we die, okay? So in some trusts, that can be, all three people can be the same. You can be the trust maker, you can be the trustee managing your own assets, and while you're alive, you can be the beneficiary, so you get the benefit of those assets. You can never be the death beneficiary if you're the trust maker, because once you die, you can't benefit from that anymore. So let's talk about what can the living trust do. Now I say the word living trust. What living means is that you actually put this trust in place while you are alive. You actually draft the document while you're alive, and you actually retitle your assets into the trust while you're alive. Because if you just draft it and sign it, but you don't get your assets into it, then you've just wasted your time and money on a piece of paper. You've got to actually do the follow through and the funding of the trust for it to be effective in any way. And once you do that, the trust can own property, so it can own real estate, it can own stocks and bonds, it can sell property, it can transfer things in and out, it can make loans or gifts. You can receive income off the property in the trust. So your securities that are growing, you can take that income out if you want, or you can reinvest it. If you've got rental property in there or commercial property, it's making money for you, I hope, and you can distribute that income out. You can make investments and certainly make charitable contributions from a trust as well, okay? The focus here is that these are trusts you put in place while you're alive to manage your assets while you're alive. Now, this is kind of just a picture that shows that individually, before I do the trust, I own all these things in my own name. And so after I do the trust, it would be, I guess we don't get a picture of what it looks like in the trust, but it would be in a nice little funnel that shows you that you, A, would avoid probate by the things that are in the trust, and then it's distributed to beneficiaries thereafter, okay? Now, living trust, the three that we're going to talk about today. One is a revocable living trust, but we are not going to be talking about it for the purpose of avoiding probate. We understand just from the basic 101 that if you have your assets in the trust, those assets in the trust will avoid probate. That's not the purpose of our discussion today. It's how can we use a revocable living trust to save money on capital gains taxes with highly appreciated assets. So that can be highly appreciated real estate, or that can be highly appreciated money managed accounts. The second type of trust we're going to talk about today is the irrevocable grantor protection trusts. And I know nobody likes the word irrevocable, but I'm going to talk to you about why it's not so scary, and certainly why the benefits outweigh the scariness. The third type of trust we're going to talk about are called retirement benefits trusts, and how we can really leverage our retirement funds for legacy, generation after generation planning. Okay, so in basic sense, for people who are graphically visual, the revocable living trust on the left-hand side is like an open box. Okay, now why that's important to know is that when you create a revocable living trust and you put your own money in there and you are the beneficiary of that trust, you have total access over those funds, you have total control over those funds, and you can do whatever you want to with those funds. But because it's open at the top and you have full access and control, there's absolutely no protection from creditors, and there's no protection from a tax standpoint in the general sense, okay? So I don't want you to see a revocable living trust as asset protection for you while you are alive, and not even capital gains protection for you while you are alive. The only kind of protection we can get from a revocable living trust is, number one, avoid probate, but number two, protections for other people when we die. So the second one in the middle is called the irrevocable grantor trust. The picture just represents that we use this one a lot for real estate that has high appreciation. Okay, and we'll talk about that more later. The one on the right-hand side, which is a closed box, indicates that it is a retirement benefits trust. And ultimately, it can be an open box in the beginning, but once you die, it's closed. And it only takes effect when you die, which is why I have it closed altogether. Okay? So the important thing is you get to keep control, buy and sell the assets as before, change, cancel anytime, which means on the revocable living trust, you can change any terms and you can say, I don't want this at all. On the irrevocable trust, the way we draft things, because we're specialized in knowing that people will age, people will decline, and people will need things out of that trust that they weren't expecting. So we can, and also we've seen that people change over time, and good people sometimes aren't as capable of being honorable later on in life when they have other needs. And I don't mean the seniors that need help. I'm talking about the children who might need to borrow money. So we want to make sure that our grantors always have the right to change who their beneficiaries are, who their trustees are, and things like that. Which means that the trust truly does contain your instructions for now and for the future in case your desires change. So let's talk about the first trust. And the first trust that I want to talk about is that one that I showed you that was in the middle, that had the little house in it, the Irrevocable Grantor Protection Trust. Now, the purpose of this trust is ultimately, as I have here, saving the house. Now, many people, their biggest asset with net value is the house. Second to that, I would say, are retirement funds. But so on this slide, we're going to talk about saving the house. So when we own a house in our own name, let's talk about that first. When I own it in my own name, if I were to sell that house, and if it was my primary residence, and I lived there for at least 2 out of the last 5 years, then when I sell it, I can have what's called a 121 capital gains exclusion on the sale for up to $250,000 if I'm single, $500,000 if I'm married. Okay. Now, if I decide to keep the house until I die, and it's still in my name, and then when I die, it goes to my loved ones. I paid $100,000 for my house, and now my house is worth $700,000. When my beneficiaries get the house at my death, they get it at what's called step up. They get it at the value of my death, the $700,000. And if they sell it the next day, they don't have to pay tax on that. If they hold it for a while and it continues to grow, they'd have to pay the difference between the death value and the sale value and pay tax on that. But what they don't have to pay tax on is all the way back to the $100,000 that I paid. Okay, so that's a benefit if I own the property and I die and it goes to people. And so certainly, also, I'm not dead yet, so I still live in the house. And if I own it, one of the biggest, smallest property tax incentives I have right now is that I get homestead, right? So it reduces my taxes. Then versus if I had an investment property or a second property where there are no homestead deductions or discounts or anything like that. So those are 3 advantages I have as a homeowner, and that as I individually own the property. Now let's pretend for a second that you're like some of my clients that call and say, hey, I want to protect the house, and I was told by a real estate lawyer I can just give it away to my child, and in that way, if I need nursing home care in the future, then the state can't take it if I go on Medicaid. And I'm like, that's right. The state can't take it if you go on Medicaid, but you know what the state and the federal government will take? That's called capital gains when your child decides to sell that property. And you know what else they're going to take? They're going to take higher property taxes until they sell it, because now it's not a home place anymore, and so you don't get homestead exemption. And you know what? They're not going to get that 121 capital gains exclusion, nothing like that. So how can we protect it if that's what you want to do, is protect it for whatever reason? Let's say it's a rental property, so you're not getting the homestead, but you still can get the step up in basis at death. Let's say that you do want potential Medicaid in the future and you're planning at least 5 years in advance. So we would say, instead of giving it to your kid, let's put it in that trust that was in the middle that had the house. When we use that type of trust, it's irrevocable, and I, as the trust maker, I can be the income beneficiary, which is good. That's what helps me keep all the same tax advantages as if I still own the house myself, okay? But yet, because it's irrevocable and I am not what's called the principal beneficiary, I'm not the one who, if I said, look, I need all that money back, I can't get it back for me personally. So that's how it protects it from Medicaid, and that's how it protects it from creditors. So if it is a rental house and someone wants to sue me, they only can sue what's in that trust, and they can't sue me personally outside the trust if it's related to that house, if that the reason for the suit is related to the house. So It's protected from creditors. It's protected from Medicaid. It's protected from other things. And I still have the same tax status as I did before. So now when I die, if it's still in the trust, my beneficiaries of that trust still get the step up in basis. Now, if I've still been living in it and I decide to sell it, even though it's in the trust, I still get the 121 capital gains exclusion. And if I still live in it and it's in the trust, I still get the homestead exclusion. So that's a big thing that for people with businesses, with people who have expected illness or decline and may want to be protecting their assets for a day when they might need or desire Medicaid, this is a great trust to use for that and protect all of our individual tax benefits of home ownership. So the next trust I want to talk about is the Retirement Benefits Trust. I love this, and I rarely hear about it from CPAs, from tax advisors, or from attorneys. And the reason I believe is that trusts are complicated. Just name a beneficiary outright, and you avoid probate. Everyone seems to want to avoid probate, and that's the only single issue that they plan for. But let's take a look at why I love this so much. So the purpose of this trust is truly generational savings. And it's to minimize taxes at death and stretch them out over the lifetime of the next beneficiaries. And while we're stretching it out over the lifetime of the next beneficiaries, that asset is also able to benefit from the compounding interest that's accruing over continuing to be able to hold on to those assets. Generally speaking, when someone dies, let's just say I have a retirement fund of $300,000 and I'm not married, but I have 3 children, and the 3 children are 10 years apart, okay? And if I just leave my retirement fund to my 3 children, if I'm not getting my required minimum distributions out of it yet, which is required at 70 and a half years old. So like right now, I'm about to be 49 years old. And if I died, I'm not taking my distributions yet, but yet beneficiaries have to take that distribution, 100% of it, within 5 years of my death. Now, that's, you know, in that situation, you would say, well, at least we can break up that distribution within the 5 years, so that way they can spread the taxes out. Because you know what's going to happen when they have to take those distributions? They have to pay tax on that, because I haven't paid the taxes on it. It was deferred retirement funds. So I'm not talking about Roth IRAs. I'm talking about all the other kind of retirement funds. And so they have to pay taxes. So from the beginning, I'm losing approximately 35% of my money just because I died, and my beneficiaries have to take that, they have to pay that tax. And they have to do it within that short period of time of 5 years. Now, it also is going to alter their tax brackets, because that's taxable income to them. So it'll bump them into another tax bracket potentially. Now, do you think most people spread it out over 5 years? No, they take it the first year. And so then all that tax is in the first year. So what we prefer to do is say, let's stretch that out as far as possible so that we can pay minimal taxes and let that account continue to grow. Those people do still, those beneficiaries do still have to take required minimum distributions, but now instead of a 5-year period, they can stretch it out over their lifetime. And when we do it right, each of those beneficiaries, in my example, I had 3 children and they were 10 years apart in age. When I just leave it to my children as a class, whose age do you think that they would base that on? The oldest one, of course, because the oldest one is going to have to take out more money and pay more taxes sooner. But when we do it right, each of my children will be able to base it on their own individual age and stretch it out independent of the other children. So it allows us to maintain control of it. The other thing that I love about this is that when we have married couples, even if it's first time marriages and you share the same children, men want to protect their wives, wives want to protect their children. And so what happens is, of course, spouses name each other as beneficiaries. Why would you do otherwise? And then they'll name their children as backup beneficiaries, hopefully, not always, but hopefully. And so then a spouse dies. And in this example, let's pretend that the wife dies, okay? So years go by, the husband gets remarried, and he's in love, as he should be, and he's enjoying life, as he should be. And he gets to a point where he's like, you know what? I feel bad that I'm not naming my wife as the beneficiary, because after all, we're married, we're spouses, and we've been together 20 years. And so he'll now name the new spouse as the primary. Well, then what does that do? It cuts out the children. Even if he names the children as secondary, if he dies first, the wife becomes the owner and she can change it to whoever she wants. And it may not be his children. So we can actually maintain control of that. And we can actually say, instead of my IRA beneficiary being my spouse, it's my IRA beneficiary to my spouse in this trust for as long as my spouse is alive. And then when that spouse dies, then it goes to my children. So that way we don't inadvertently cut children out. And that becomes even more of an issue with blended families from the beginning, wanting to protect our own children from our side. So that's another issue there. So let's look at some of the examples. And let's look at, sorry, I want to actually get to the examples. So in this, John is the owner of an IRA. In his IRA at December 31st of 2018, he had $250,000 of value in there. At that age, he started taking his required minimum distributions, and he took that until he was 86 years old, okay? So for 16 years, he pulled from his IRA. And at that time, he died. And when he died, his collective distributions were $281,000. Now his spouse gets the rollover, and she was 82 when he died, and then she lived for 3 years. And so during that 3-year period, she was able to take out basically $89,000. Still good, all sounds good, much better than 250. Now, when she dies, they do outright distributions to the son and grandson, who each get $165,000 essentially. Okay, still good, not chump change there. But if they had done it in a trust that used the life expectancy of the son and the life expectancy of the grandson, then the beginning balance stays the same at 250. John still gets his 281. Mary still gets her 89. But the son, over his life expectancy, he would get to pull out $521,000. And certainly he's older than the grandson, so his is much shorter and much less money. But the grandson, based on his young age and his life expectancy, he's able to get $1,625,000 out. So the difference with no trust was $700,000 total family benefit. With the IRA stretch out trust for beneficiaries, total family benefit is $2.5 million. And so I ask you, how does that not make sense to stretch that out and be able to leverage those resources that can be managed and used in ways that are hardly conceivable to John and Mary at this stage, right? So we would say that anybody with retirement funds of $250,000 or more should really consider this option. And the reason I say 250 or more is because if it's less than 250, then it, from a financial standpoint, just really doesn't make sense. Okay, it doesn't make sense. There are other reasons that it makes sense to do the trust other than just tax planning. And I want to go back to a couple slides that can outline some of those reasons before we go on to the other thing. And so essentially, when our beneficiaries wouldn't make good choices, we would want to consider an IRA beneficiary trust, in addition to the tax planning, which we already talked about. If there's children from prior marriages, if we want to benefit the spouse but ultimately go to other people afterwards. This is a big one, is our beneficiary, if they get divorced, that can be split in a divorce. The other thing that changed in 2014 was this Supreme Court decision, Clark versus Remacher. And basically it says IRAs are subject to bankruptcy, foreclosure, bankruptcy. And yet, if it's in a trust, an IRA beneficiary trust, it is not subject to bankruptcy. And so if you've got beneficiaries who might have some financial difficulties, would you want your money to be paying off all their financial difficulties, or would you want that process to take care of itself and your IRA taking care of them? Okay, so those are the IRA beneficiary trusts. The last trust I'm going to talk about before we open it up to questions is the revocable living trust with a very special provision called the Clayton election. And so it looks like a revocable trust. It's all the same flexibility as that open box I talked about before, except this trust has very specific language to maximize your ability to get step up in basis on highly appreciated assets when you die, and then also when your spouse dies. And so this particular trust really only benefits married individuals. Okay, so it's not beneficial for singles, because this is the case. So Maggie is holding assets for John and Mary, and they have a joint brokerage account. And they say, well, we're good. When John dies, Mary gets it. When Mary dies, John gets it. We also have transfer on death accounts, which is good. It goes to the kids. So let's say they started with Maggie 20 years ago, and they started off with $100,000. And Maggie, has done really well for them. And now that $100,000 is worth $1 million. Okay. Now, that $1 million is jointly owned. So when John dies, half of that account is considered his. So half of that account would have a step up in basis from the 100,000 to the 1 million. So basically, let's just say $500,000 is step up in basis. So Mary could sell all those shares if she wanted to and not pay tax on his half, but she's still bound by her low basis on her half. Okay, so she can't touch that unless she wants to pay taxes on that. But if we use this trust with the Clayton election, there's language in there that says it doesn't matter who dies first, we get a step up in basis of the entire account when the first spouse dies. And lo and behold, years later go by, when that second spouse dies, we get another step up in basis, which means the children get it without capital gains at that point. And nobody's doing that kind of planning that should be doing that kind of planning when they have accumulated assets over time like that. So that's a huge benefit of that trust. And even people who have done planning, like Joe Robbie, who'd had the revocable trust, didn't do the kind of planning that would protect his estate from estate taxes, capital gains taxes, or anything else. So let's show the example here. We've got $1 million of highly appreciated stock. It's got capital gains tax if you sell it. Instead, we can create that trust that has these special provisions that allows the spouse to use it when the first spouse dies. It allows the grandchildren and the children and grandchildren to benefit from it as well. So we transfer it to that family trust instead of giving it to the IRS. So no capital gains on that when done properly. Okay. The alternative is paying $200,000 to the IRS. We don't want to do that, right? I don't want to do that. I'd rather our family keep it and really enjoy it the way that it was intended. So Today, you've heard three, hopefully new options that have not been presented to you or that you haven't taken action on. Lots to think about. So I'd like you to just imagine, how you'd feel when you have the right plan in place, not just the plan that the herd has, right? You want to make sure your family has the peace of mind that they don't have to sell everything just to pay your taxes. And you certainly don't want this to be your plan. So let's create some certainty. So these are just some client testimonials from my firm as far as the work that we do. I'm sure that, Maggie has just as many, and certainly with our combined clients that we work on together, they're extremely pleased. So what I'd like you to do is take the time to talk with your advisor at Chicory and determine if income tax planning with trust might be right for you. And just know that if you're a resident of Georgia or Michigan, we can help put a plan in place if that's what's right for you. Okay, so Maggie, I'm going to open it up to you, see if there's any questions, see if you'd like to comment on anything that we discussed.
Yeah, thank you very much, Victoria. This is great. I really appreciate it. And we do have some questions that came in, and I want to sort of challenge one thing gently, just so this is a gentle challenge or a clarification on non-spousal beneficiaries for traditional IRAs or Roth IRAs. Just to clarify, I hear what you're saying about the elements of the retirement benefits trust and its values for a lot of things. I have situations where clients have named trusts, and we're actually enacting that, where there's a trustee on the beneficial IRA. But just for clarification, an individual non-spousal beneficiary can now stretch those required minimum distributions over their lifetime. Just to be clear, that did change the tax law.
Yes, so it's my understanding, and I'm not a CPA for sure, but it's my understanding that that's only if the individual who owned the IRA to begin with was already taking their required minimum distributions. So if they're 70 and a half and above and they're already getting those, then yes, a non-spouse beneficiary can continue that over their lifetime. But it might be grouped as a class so that you're still stuck with the age of your siblings. But if they're not taking RMDs,
if they're named, if the individual is named as a beneficiary, even if the person hasn't begun RMDs, actually, it's our experience that they can still stretch them. But thank you for that. We'll go back and double check the fine points on that.
And I will.
Go ahead. Go ahead. What were you saying?
I was going to say, and I will as well.
Yeah.
So it might not be, if they did change that and it's that way that you don't have to be taking your RMDs for your beneficiary to get that stretch out, then the advantages would be that we'd be looking at, can it be the individual's age, or are they grouped with their siblings and stuck with, a larger payment than they needed to, and a shorter life expectancy. And the other is certainly the other reasons in the trust is from creditor protection, divorce, bankruptcy, all of those other issues too.
Exactly. And that was going to be my next point, that there are plenty of reasons to consider doing it the way you're suggesting that don't necessarily relate to stretching it out. So all that to say, I hear that. So you and I can take that offline and get to the bottom of it, but just didn't want there to be too much confusion on that. We have some other questions though. The first question that came in was, and this is true, we have a number of clients who have this situation where they own property, and they own property in two different states, for example. In the case of a situation, let's just say you have a property in Georgia and a property in Florida, can those properties could those properties be titled into a single trust, and thereby, and of course in this case, at least minimally, it would be avoiding probate in two states. But are those two, or is that one trust or two, was the question in a case like that?
So you can, in fact, put both properties in one single trust. And in that way, you would avoid probate in those two separate states for that piece of property. The question is, should we put it in one trust or two? And the answer lies with what are the risks that we are exposed to other than probate. So for example, if one is a rental property and one is your home place, then you might want two separate trusts, because the rental property, there's a higher risk of being sued when somebody slips on it and thinks you've got lots of money and want to sue you. If it's in a separate trust from your home place, then they can't attack the value of your home place. But if they're in the same trust, they can. So the answer is yes, you can do it. The question is, does it make the most sense to do it?
And then the follow-on question, and this is a question also that I had when I was thinking about putting a property in a trust. What's the distinction between putting a rental property, for example, in a trust and putting a property in a limited liability corporation, for starters? What's the protection differential? And then the follow-on question is, can a trust hold an LLC itself? So let's say the property in an LLC, then you put the LLC in the trust. And what's the differential in terms of protection for the owners?
Yep, great. So people will put properties in LLC, especially like rental properties or commercial properties in LLCs. Those are business entities, and when you operate them like businesses, then again, it shelters you personally from liability if you get sued or you don't pay the taxes on that business or something like that. The issue with a business, an LLC, is that it is considered personal property from an estate perspective, which means it is a probate asset.
I see.
And so a trust would keep it from going through probate, whereas an LLC itself is a probate asset. Now, what many people do is they will create LLCs or let's say I have 10 rental properties. I'll create 10 LLCs for each of those rental properties, and then I will put them all in one trust. Now, different than the example I gave before, if they each have their own LLCs, but they're all in one trust, then if somebody wants to sue me on one property in an LLC, they can still only get the value that's in that LLC, even though that LLC is in the same trust as all the other LLCs. The benefit of putting them all in a trust together is now you have one trustee who's managing all those in one way, right? So it's kind of like a parent company with lots of little baby companies managed by one entity, and they all then would avoid the probate as well. So that's really aggressive asset protection planning and tax protection planning, but also very good. Not everybody needs that level, but it certainly is a level that is available. The other thing too is if you've just got a couple rental properties, you might want to just use trust without LLCs. And the reason for that is LLCs come with annual registrations. It comes with annual fees, whereas trusts don't, especially if you're your own trustee.
Very, very good. Okay. This is a question about the revocable living trust with the Clayton election, which I have to just say, this revocable living trust with the Clayton election is fascinating to me. And I'll ask my client's question, and then I'll ask a follow-on question. My client's question is, must the heirs of an RLT with the Clayton election for a married couple be the children of the couple, or may other individuals be designated as beneficiaries at the death of the second spouse? That's the first question. My follow-on question is, there's got to be a catch to this thing. Come on, what's the catch? Okay. I mean, this just sounds too much like a free lunch, but you can answer that secondarily. Answer my client's question first, please, if you don't mind.
Well, so I do believe that it can be other individuals besides the immediate children, family members. But what's the catch? Ultimately, someone is going to have to pay those taxes at that non-spouse level when they liquidate those resources. So it's not tax-free forever. It is taxable at that child/grandchild level, or whoever it is you give it to that's not in the family, unless of course it's a nonprofit. So that's a wonderful way to avoid. So we've got married couples that don't have children, right, or don't have other people that they want to leave their stuff to, and so they can avoid the capital gains while they're both alive, but then give it to a nonprofit, and that's good planning.
So
as well.
just so I'm understanding, let me walk this through. So my spouse and I, we have a revocable living trust with a Clayton election, and
Mhm.
I pass away, and my spouse gets a step up in basis on anything that's in the revocable living trust uh, at my death, and the whole everything steps up at that point, right? The whole kit and caboodle, right? And then
If they make the correct elections after you've died based on the language that's available in the trust,
okay,
correct?
so it's not just automatic. There are certain things that have to get
Right.
done, but then all
Right.
of a sudden we've got 100% step up in basis on everything in the trust. And then she, being naturally grieved because I have passed away, within 5 minutes dies, but not before making the election. Let's just say.
Mhm.
And
Mhm.
now what happens to the basis? Does the basis revert, and my beneficiaries now have to pay? No, they get it. They get a step up anyhow, right? Right?
Right.
Okay.
Right.
So they get to step up. So really
Mhm.
what we're doing is we're stepping up for the surviving spouse
Correct.
100%, not just 50%. That's
Exactly. That's the benefit right there.
got it. Got it.
Exactly.
Okay.
Okay.
And
Um,
then the second death, there would have been a step up anyhow for
anyway,
the kid. So you
exactly.
don't really do this
Anyway.
for the kid, you do this for the surviving spouse.
Exactly. And so I'll give you an example. There's this really rich I just spent the week in the British Virgin Islands last week, and we
Right?
chartered a yacht one day. And so the captain of the yacht was telling us, the people who lived on the other islands and owned the other islands and all this kind of stuff. And one of the stories he told us was about this woman who, she and her husband, billionaires, and when he died, she took a large portion of, or I don't know, a large portion, it's probably a small portion to her, but took an amount and bought this humongous yacht that she is on like 3 months of the year, but it cost hundreds of millions of dollars. So, she liquidated securities to then buy this yacht. And so that's, a real world situation where people don't just hold on to the money always. Sometimes they do want to do things that when they were married, maybe another spouse wasn't, all keen on at the time. You know what I'm saying? So,
No, I know exactly what you're saying. Yes. Okay. Okay. And also, I suppose if you had a business, you'd want the business in there so that if the spouse wanted to sell the business, she or he could sell it without capital gains, without a huge capital gain, too.
right,
Yeah.
right, because the business is valued as well.
Got it. Okay. Next question. Is there a kind of trust? I think this is from a client of mine, and I'm afraid the answer is no. But here's the question: is there a kind of trust that can hold cash of a sold asset until the individual dies, so as to not create a capital gain event? I think, in other words, um, maybe someone, mother, or wants to liquidate assets, but has huge capital gains, trying to find some way around the capital gain step, in the absence of a step up. I mean, is there anything in life that can avoid capital gain? I don't think so, but
Um, well, the only other stuff, which is outside the
real
scope of this,
example.
is the charitable planning, where you're using your what's called grats and gruts and stuff like that, which are charitable remainder trust, charitable annuity trust, where perhaps you give like a family member a lifetime income in it or something, and then a charity gets the rest at a certain time or at that person's death. So there's definitely planning that can be done to minimize capital gains in a situation like that, but you have to involve charities for that.
Right. So, yeah, so like a very highly appreciated asset, like a piece of real estate, for example, where you don't have a spouse, older person needs to sell a piece of real estate, doesn't want to incur the capital gain. Yeah. Um,
Mhm.
hmm, some kind of, yeah, right. You have to involve a charity, but you could involve a charity in such a way that the asset reverts to the child. There are ways to do
Right.
that, right?
Right. So there's what's called the charitable lead trust, where the charity gets the income for a period of time and then the rest goes to the child. So there's different ways to do it depending on what the goals are.
Right, right. Okay, that's helpful. I think the charitable lead trust in this instance might make some sense. Another question I have for you, myself, that I'm I'm curious about. So this is more to the asset protection question. So let's imagine you have a spouse, married couple. Um, One couple holds all their assets or a lot of their non-qualified assets in their name alone. If the other spouse triggers a Medicaid need, let's just
Mhm.
and so this person's spouse triggers a Medicaid need, how or are that those spousal assets held in that spouse's name alone protected or not protected from a Medicaid clawback? Does that make sense? Do you understand what I'm asking?
I understand what you're trying to ask. Yes. So
Thank you.
let me. So first of all, when we say Medicaid need for everybody who's on the call, I would say that we only have a Medicaid need when we have a person who needs nursing home level of care.
Right.
And we're in a nursing home level of care. We have two questions. One is, do we want to spend everything down until we by default go on Medicaid? Or do we want to utilize the laws available to us to protect as much of our assets as possible and still at some point qualify for Medicaid? Okay. And so your question is, if I have a person in a nursing home and we want to get that assistance to pay for care, and how do we protect the spouse's assets at home, even though they're all in the spouse's name?
Mhm.
Can we do that? Is it subject to Medicaid? The bottom line answer is that they're going to, so to qualify for Medicaid, you have to be under a certain asset limit. And that asset limit is different whether you're married or single. And it's a federal program, but every state administers it differently. So I can't give you a very specific answer on here. I can give you a general answer. And that is that the spouse's asset, the one who's not in the nursing home, is going to be considered an asset against that limit that the one in the nursing home is allowed to have.
That's
And so,
okay.
yes, so it is subject to it, even though it's only in their name. So then the question is, what are the planning tools we have available to us under the law to protect as much of that as possible while still getting Medicaid? And that answer is going to differ based on what state you're in.
Right. And I don't need to get you in the weeds on Georgia. We'll have you come back and do just a separate thing on that alone, perhaps. But in this case, it's a Georgia case I was thinking about.
Yeah.
Okay.
And that's, yeah. And that's the kind of stuff we work with all day long.
Right. Right. Yes, I'm aware of that and I've worked with you on some of that, but do not pretend to have the ins and outs of that even remotely around my mind. All of these techniques you've described today, Virginia, are there's nothing state specific to any of this, really, from what I'm understanding. Correct? There's nothing other than the Medicaid stuff we just launched onto. Nothing else is only Medicaid and its vagaries are state specific. The rest of these things just relate to federal tax law. Correct?
Exactly. It's just federal estate tax laws.
Right. Right. Okay. Great. I'm just looking to see if any of you have any other questions. If you've not found the chat feature, I'll just give you a second. We're about ready to tie up. Think that's Thank you, everyone. We had almost everyone stay on the call to the bitter end, including you and I getting in the weeds on required minimum distributions and stretches. Victoria, thank you.
Well, what we can do is after we've clarified that, maybe we can send out an email to
Yeah,
everybody
we'll
who's
get that
registered.
clarified for sure. Yeah, and we will. And just again, thank you all for joining today. If you do have other questions, don't hesitate to email me directly, or of course, Victoria. Her contact information is on the screen. And we're just grateful that you all joined. And again, thank you very much for your time today, Victoria. This was extremely interesting. And definitely going to be checking out that revocable living trust slash free lunch Clayton thing for sure. For
Yeah.
sure. That's a cool little thing, cool technique.
Well,
Okay,
thank you.
I guess that's all for today. So thanks, folks. We'll be signing off. Have a great rest of your afternoon.